We apologize for the technical difficulties at the start of this webinar. The PowerPoint presentation begins at the point where the audio recording starts. To view the PowerPoint presentation in its entirety from the beginning, visit www.venable.com/nonprofits/recordings. Click on the event listing for this webinar, and then click on the downloadable files link in the left-hand column, which contains the presentation slides. Again, our sincere apologies for the technical difficulties.
Formal contracts, agreements, one-off, statements of work for an event on a per-event basis. But making sure that you're in compliance with the local laws as they might apply and protecting your own interests. And frankly, the use of IP in those agreements is often a sticky contractual provision that we see. And we'll touch upon that later in more detail. But just ensuring that the contract does set up bright lines for how that non-U.S. organization will be using IP or jointly using IP with your own is important.
So then further progressing, we often see the joint venture approach. And as Carrie had mentioned, that's essentially something where you have your organization, the other organization may already exist, or it may be a new formation, and effectively you come together for a new entity. And some of the issues that arise there are different in that, for example, the intellectual property that's developed by this new combination, this new joint venture, who has ownership over that? Are you going to license your name, your brand to them? Are you going to establish a new joint name and brand? Who's going to record that particular intellectual property? So a joint venture is further in the spectrum. You're more invested, you have more control. You also have greater risk because you're really now embedded with this other organization. So it is critical to have your, is that clicking over? To have your ducks in a row to ensure that, in fact, you've got a good understanding as to who you're dealing with. And frankly, that goes across the board. Your due diligence on your partners is paramount. The other important issue is under the local laws, are you now doing business? Are you now transacting and establishing in an environment where you're subject to liability as a U.S. entity? Have you progressed to that point where you actually have an organization there where liability, tax, accounting, and other issues come to the fore? Or are you protected by this joint venture? Oftentimes what we'll see is a U.S. entity will form a second entity that will be the organization that in fact deals on their international front. Again, it raises a first line of defense, if you will, to some of the liability issues that can come up. So again, it's segregating what you're doing domestically from what you're doing internationally. Now, that may be too burdensome. That may require too much administrative duplication, if you will. So there's a pro and a con to that. Also, an important area we talked briefly upon before is the FCPA, as it's known in the U.S., Foreign Corrupt Practices Act, U.S. statute and law that's been around for over 15 years here. Is now much more common. You'll see anti-corruption laws and regulations globally. In many parts of the world, dealing with local government officials is the norm, and frankly, the bribes or grease payments that you see, has been a historic issue of quote-unquote doing business in that country. The trend has certainly progressed, but the important part for everyone here to consider is that the actions of either your joint venture partner or your agent or whomever can be affiliated with your entity. You're the U.S. person as it's defined, U.S. person being either an actual being, a corporate entity, a nonprofit, some other organization here in the U.S. So again, bearing in mind who you're dealing with, your joint venture activities, you're much more closer to them, you're closer to the action there, but that comes with greater responsibility as well. And then finally, we see folks who have oftentimes progressed from putting your toe in the water to diving in. and that's where you're establishing an entity under the local laws. Obviously, all of these issues and these approaches must be carefully considered with complying with local law. You know, we have our own set of laws and regulations that you don't want to upset the apple cart. You want to make sure that your nonprofit status is intact. Likewise, when you're going overseas, there are local laws, and more importantly, interpretations of local laws that really require guidance with local counsel. What we do is we bridge that gap. We work with local counsel around the globe to ensure that your U.S. interests are protected and the local involvement is also in compliance with those laws. So when you're talking about setting up an operation in a particular country, you have to obviously follow those local laws. You're there, you're the organization. You don't have the buffer of a joint venture partner. You don't have the buffer of an AMC. You're there. So again, along the spectrum, that's probably the most important point in which you as a U.S. entity say, how do I best protect my U.S. assets and directors? And there, typically, we will see a separate entity that has been created to deal with the international aspects of their operations. So again, as we've seen before, you've got then local employment and tax considerations because you are then doing business in that foreign jurisdiction or jurisdictions. There may be some variation in terms of how that jurisdiction deals with nonprofit status. How is it recognized? How is it developed? How is it sanctioned by the country? All of those are considerations to bear in mind. And then, of course, paramount is your tax-exempt status. Yes, we have a question.
Is there a tipping point at which the U.S. becomes concerned about your 501c3 status?
Okay, so the question was, is there a tipping point in when your 501c3 status is affected in doing business abroad? I would say any time you go overseas, you want to discuss with your counsel in terms of protecting that status. And Jeff, do you want to jump in?
Yeah, I mean the general rule under for all categories of tax-exempt entities or most categories is that whatever you can do here within the scope of your exempt status and your exempt purposes, you can do overseas, even exclusively. Even if you're exclusively operating overseas, as long as you're operating within the scope and bounds of your 501c3 exempt status and purposes, you're okay. Now there are special rules and special limitations when it comes to taking U.S.-based, U.S.-sourced money and giving it to foreign organizations in the form of grants or other things. There's some very tricky rules that come into play, and if you're thinking along those lines, that's something where you really need to consult counsel on. But generally speaking, the international aspect of your operation should not be an impediment because of your C3 status.
Yes, another question.
A related and follow-up question. In some jurisdictions, the only way or most expeditious way to proceed is to set up a for-profit entity. Assuming one continues to be within the scope of one's 501c3 permissible activities, does this raise any other issues?
Well, as Lindsay and Carrie are going to get into, you're exactly right. In certain countries, and I see some of our clients here around the room with whom we've talked and counseled on these issues, and for various reasons relating to the local laws in those foreign countries, you sometimes have no choice but to form a for-profit stock-type corporation in those operations. And as most of you probably know, it's completely appropriate and well-established U.S. tax law that it's okay for a U.S. tax-exempt entity to set up for-profit subsidiaries, whether here in the U.S. or overseas. So as a general principle, that's something that's okay. You, of course, need to be very cognizant of all the rules that relate to how the U.S. tax-exempt entities' resources and funds are used to subsidize that for-profit entity, because you cannot just take money that's within a tax-exempt entity and just give it outright to a for-profit company. You can do things like capitalize the entity in exchange for stock or the stock equivalent. You can pay funds in exchange for fair market value services or other things in return, but you can't simply just give money outright to a for-profit company, in certain exceptions, and with in the exception of certain controlled grants and things like that. So bottom line is, yes, you can go that route. In some cases, you have no choice but to go that route, but you do need to be cognizant of the tax rules too.
And I would add to what Jeff said as well, is that in some of these foreign jurisdictions, establishing a nonprofit entity is a very time-consuming and complicated endeavor. Oftentimes, you don't have a choice in the other direction. That is what you would have to do. But in jurisdictions where there is a choice, we have worked with local counsel and given the laws here that allow a 501c3 entity to work with a for-profit abroad, that has been the ultimate decision, that the for-profit is the more economic, expeditious way to go. So we've seen both options.
Okay. Continuing along. So geographic location and choices, typically that's driven by need or business opportunity. There are some trends that you see lately. It seems as though certainly Asia, India are top of the list of interest. A lot of opportunity, I think, in both of those geographic locales. They both raise unique issues and challenges. So in thinking about when you're going overseas, where are you looking to establish your entity? Are there onerous registration requirements that we talked about in order to even begin your activities there? For example, in Singapore, even if you're going to have a one-time event, you need to register under the Societies Act, even just putting on a conference. So that, in comparison to Hong Kong, where you can come in, do a conference, you could do multiple conferences before you have to jump through the hoops of more formal activity. So there is a range. They're both within Asia, but obviously very different organizations and jurisdictional requirements in order to participate there. Whether, as we mentioned before and based on the last question, you need to consider and balance what exactly will be required. Is it expensive? Is it time-consuming? Can you set up your organization overnight, or is it going to take months and months and layers of approval? Oftentimes you'll see provincial approval, federal approval, which can impact your decision in terms of moving forward. And also your time frame. Going back to what's our first question, what are your goals? Are you hoping to have operations up by March 1? Or is September a more reasonable timeline for what you're hoping to accomplish? And then also contemplating, is there a tax treaty that certainly can impact your operations? Is there a tax treaty? Should tax implications arise? Is there a bilateral or multilateral tax treaty with the U.S.? And for all of these, we provide guidance from our perspective, but it really is critical to work with our network of local counsel who are familiar and well-versed in dealing with nonprofits in their local jurisdictions as well, so they know the nuances and can help guide us in the most expeditious manner.
Yep. A few other factors that are sort of outside the scope of the organizational and event-driven thought process are U.S. export controls and other U.S. initiatives that might also guide or affect your choices in deciding on a foreign jurisdiction. Something that we'll get into more detail about later are the existence of U.S. export controls or economic sanctions in certain countries. Oftentimes we've seen that in developing nations there may still exist certain export controls on the export or release of technology and certain materials. Sometimes a license is all that's required, but in other cases, economic sanctions do apply to U.S. persons. As a U.S. nonprofit entity, you would be considered a U.S. person under these rules and regulations. The economic sanctions are U.S. person specific, and they are with regard to transactions. And so any membership dues that may be transacted with either persons that are affiliated with the government of certain countries or persons that have been designated, we call them specially designated nationals by the U.S. government. And so the existence of these rules and regulations are also something to keep in mind. And again, we'll go into a little bit more detail about that later. Also, as Lindsay mentioned, in considering whether to establish a joint venture or an in-country branch or entity in countries, the idea of what is the risk as far as under the U.S. FCPA, the Foreign Corrupt Practices Act, and other national anti-corruption legislation. The Transparency International puts out what's called a corruption index, as does the OECD. These rank countries as far as what type of corruption risk may still exist historically, whether it's been an improvement. In developing nations, we often see this as a tool, as sort of a first step threshold look at the jurisdiction. And finally, in March of 2010, under the Obama administration, the National Export Initiative was launched. And under this initiative, we've seen a real focus by the administration on increasing exports, both of technology and information, as well as commodities and goods. And that may affect your target industry under your nonprofit. Are there green technology initiatives or incentives to go to one country versus another? And these are all also things to consider, factors to consider.
So talking about the agreements and the importance of the provisions there are several that you really want to focus on. A little feedback here. Obviously, any agreement, you want to make sure that is in your best interest, and like anything, it's a negotiation. You'll have to think about it. Do you have the upper hand in terms of either selecting a partner or selecting an agent who may represent you? Those are some considerations. It'll be the battle of the forms, but there are a couple of key provisions that I would certainly recommend that you stand firm on. The ones in dealing internationally that we often see are dispute resolution. And most persons, companies, persons, individuals, are fearful of our U.S. litigation and our society, our litigious society. So what you often see is arbitration overseas. So in terms of dispute resolution, it's frankly more common to see arbitration as a means of resolution. And even there, it's a spectrum. You typically see, well, we're going to try and mediate a dispute, and then if we can't, we'll seek to more formally arbitrate the issues. Oftentimes, U.S. entities will want to put in some home cooking and say, well, if there's a dispute, we want to have it litigated in our court down the road. It simply doesn't fly. Generally, what you see happen, though, is you see a negotiation and a determination where you say, okay, let's arbitrate. And maybe it won't be the American Arbitration Association because, again, the non-U.S. party will think they're getting some home cooking there. But oftentimes we'll see an organization like the International Chamber of Commerce, the ICC. You want to give some consideration as to where the dispute will take place. Is it in a locale where English is spoken? Is it in a locale where it's going to be expensive to actually have the arbitration? Is it in a city where the prices are very high? Is it in a location where you've got sophisticated business people who will understand the issues? Those are all things to think about when you're establishing a dispute resolution. Generally, people going into a contract are thinking, about the benefits that they're going to get, the positive impact, but it's more important to think about how to get out of it and what happens if things go south. People don't want to think about it in the beginning because everyone likes to be an optimist, but it's important to consider that. In addition, to the form, you want to think about what law is going to apply. Maybe New York law won't be perceived well in China, or maybe there'll be some other requirement. Generally, what you find is you go out of the gate with your best position and then do a fallback to something that you can live with and that is also acceptable to them. So you want to think about some of those provisions in terms of dispute resolution. The governing law, it's always important to add in the magic phrase, excluding conflicts of law provisions, for any of the folks in counsel's office or attorneys around the room, because that just means you're not playing ping pong. If in fact you're operating from here, you're dealing with a joint venture, let's say in India, and you say U.S. law will apply, and U.S. law says the place of performance, and effectively everything is occurring over there. So then you're suddenly under substantive law of India. So you want to make sure that whatever law you do identify, you exclude conflicts of law provisions, so you can avoid that ping pong, if you will. You also want to focus on your IP and the terms there with regard to your intellectual property. Many countries, folks will rush to record it, and whoever records it basically controls the intellectual property overseas. And so if you don't specify, you just think, well, it's our IP, of course, and your partner may say, well, we'll be happy to assist you with that. We'll record it for you. And then suddenly they're controlling your IP in that jurisdiction. So you want to be mindful of that as well. Then
can I interject one thing on IP? On the trademark side, for those of you who are not familiar, here in the U.S., our basic system of trademark law recognizes what are called common law trademark rights that give you legal enforceable rights in your trademarks from the moment you begin using them. So your names, your logos, your slogans, etc., are subject to trademark protection from the moment you use them. The longer you use them, the greater geographic area in which you use them, the greater your rights are, even if you have never registered your marks with the U.S. Patent and Trademark Office for federal trademark registrations. Of course, doing so, the latter is very much advisable and recommended and significantly enhances your rights. Overseas, though, in most foreign countries, there is no concept of common law trademark rights. In most countries, it's solely registration-based. And in most countries, it's a first-come, first-served type of a system. So it's critically important that if you are contemplating operations overseas, even if you're not contemplating having an office overseas, but you are contemplating using or letting others use your trademarks, your name, your logo, your certification marks, other things like that in foreign countries, that you consider very quickly registering those marks with the trademark offices in those foreign countries. Those organizations that recognize the importance of this, because oftentimes your name, your logo, your reputation, your certification marks, that's 90% of the game for you. You need to protect it. You don't want others going in, even affiliates with whom you may be working, or management companies or others. You don't want others to go ahead and register those rights and put you in a very disadvantageous situation. So it's critically important that you consider registering those marks in as many foreign countries in which you're operating.
Another important aspect is the money. Everybody always thinks about the money. There's always money involved, and you don't want to find yourself in a position where you're bearing the risk of currency fluctuation. So find, whether you define it in U.S. dollars or some other currency that you're comfortable dealing with, put that in your agreement to make sure whatever payments, whatever obligations are made, that you have a currency that you're comfortable with. And then my favorite is the termination provision. As I mentioned before, it's always easy to enter into agreements, and it's very difficult to get out of them. So you want to make sure you've got clear delineation of markers. Oftentimes it's easier to go in and say, we will perform this, we'll enter into this agreement for a year, and then after that period we'll renew it again if both parties agree, rather than saying, here's our agreement, till death do us part. Those are much, much more difficult. In many countries, you have to have firm, objective standards by which you can terminate. So if you go in with a set period, you're in a better position. So people don't like to think about termination, but think about the termination provision as well. Sure.
And then I would also just add in the contract provisions, and this is going to vary on a case-by-case basis, but we advise that associations also include a compliance with laws provision. And we didn't include this as one of the specific sticky provisions because it is really going to vary on a contract agreement basis. But those specifying that the U.S. entity as well as its partner acknowledges and agrees to comply with the FCPA, U.S. export controls, and whatever other tax and what have you laws that do apply in the jurisdiction and in the United States is important. Number one, for compliance with those sort of one-off rules and regulations, but also so that the other entity with whom you're partnering doesn't do something to jeopardize your own tax-exempt status. Okay. All right, so tax and accounting considerations. At a high level, what are the international tax law questions that are applicable here? We already talked about whether a tax treaty exists with the United States. This varies on a country-by-country basis, and it can have minor effect or a larger effect depending on what you intend to do, what your goals are in that country. Again, back to that threshold question. And as we've discussed, IRS rules generally apply that apply to U.S. tax-exempt nonprofits will apply to your overseas operations as well. Another high-level consideration is what are the audit standards that apply in that country? Certain countries will accept the GAAP standards for auditing books and records. Others have country-specific standards. And again, back to the recommendation to seek local counsel, that counsel almost always has that answer handy and can assist in whether or not a form of your auditing here in the U.S. would work, or whether a separate independent audit of your books and records may be required. And then finally, certain countries, and we often see this in East Asia, do have restrictions on outflows of currency. This may not be an issue, but if you are intending to put on an event that will be revenue producing, whether or not that currency and how much of it can leave the country is often something that we have seen come up.
Okay, so many of you may have heard of the new form that we've got as of January this year that controls foreign financial accounts. And I'm just going to touch upon this briefly. We've got a whole team of colleagues who I'm very pleased to say do this day in and day out from the tax perspective. But I do want to raise this with everyone. Treasury Department Form 90-22.1 is our form, and that's effectively a rather long form, detailed form that requires reporting of foreign bank and financial accounts. Came into effect in January. It has to be filed by June 30th, reporting the prior year's activity. Importantly, it's not filed with your nonprofit income tax return. It's a separate obligation. And it's required if your aggregate foreign financial accounts exceed $10,000. That's a relatively low threshold if you think about it for your overseas activities. And that would include, again, it's aggregate, so it would include foreign bank accounts, security accounts, and mutual funds. So if you think about what you're doing beyond our borders, whether or not you have to file this form. Now, there's some question right now as to whether or not reporting is required for foreign hedge funds or private equity funds. There's still a question mark on that. So for now, as we understand, the IRS has deferred that reporting. Some other informational returns that you need to bear in mind as you're going overseas, and we've got a listing on the PowerPoint here. Form 926 and 5471 have to do with investments in foreign corporations. So again, thinking about what your activity is, what the entity is overseas. There are two other forms, 3520 and 3520-A, that deal with your foreign trusts. So bear those in mind. Form 8865 have to do with investments in foreign partnerships. So you may have a whole variety of activity, be it a partnership, a trust, a foreign corporation, as we mentioned before. Now, you are not required to file the new FACTA Form 8938. That only applies to individuals and not non-for-profits at present. So you can see we have no shortage of forms and papers to file, but do bear those in mind as you're going overseas.
And just a bit more follow-up on the updated Form 90-22.1 is that there are penalty amounts and statutes of limitation that do apply differently to filing that reform properly and timely. A $10,000 minimum penalty for failure to file, and that is per account and per year. And then unlike your 3-year tax statute of limitations, you're looking at a 6-year statute of limitations for this informational filing. And then, again, some other forms to keep in mind, $10,000 per unfiled Form 471. And based on what you're doing, 10% of your assets transferred for an unfiled Form 926. And again, any more specific questions on this, we have a whole host of our colleagues that are available to also assist. All right. So moving on to insurance and in-country employment considerations. Again, depending on where you are on the spectrum, are you partnering with an AMC for a one-time hosting of an event? Are you forming a joint venture, affiliating with a similarly situated association? Some of these may apply and some of them may not. Insurance is something that we don't always think about. You have your U.S.-based insurance policies, and oftentimes when you do partner, or just if you do partner or decide to partner with an AMC, that AMC will provide certain coverage. Looking at it and very closely and determining, is it a per event coverage? Is it full spectrum? Does it cover their employees, your own employees that may be over there, guests? These are all very important considerations. And let's see. And then for in-country employment, in using a trade fair organizer, typically we don't see U.S. citizens or employees of the U.S.-based nonprofit in the foreign jurisdiction as an employee. It's further down the spectrum, but to the extent that employment considerations are at play, depending on the jurisdiction, this really is a case-by-case basis. We see differences in employment at will considerations. Oftentimes, civil law countries and East Asian countries, civil law country example would be Brazil, do have employment at will standards that differ substantially from U.S. standards. Additionally, income that employees who are U.S. citizens incur in that country may be taxed in that country and in the United States, depending on the basis for that. And so setting up employment agreements with your employees of the U.S. entity, keeping those things in mind is important. And just ensuring that you do your due diligence, talking with local counsel on these issues, as they do vary quite significantly.
I would just add as well, there are some considerations of visa requirements and permits just in order to perform activity there that you would need to be mindful of. The employment side is one where you do see a great variation in terms of the protections that employees are afforded in other jurisdictions that can vary greatly from the U.S., so that's one where you want to pay particular attention. Okay, we touched upon this a little bit, your IP. The point we want to make here is give some thought to your IP, your registered, your recorded IP, whether it's the trademarks, copyrights, and the like that Jeff had mentioned. But then also bear in mind your confidential information that may not be something that's recorded. Maybe you consider it a trade secret, your mailing list, your membership list, other critical educational materials that perhaps you've not copyrighted, but you consider a gem for your organization, and should that get released, you don't want to find yourself competing against yourself in a foreign jurisdiction. So we also give the recommendation to have that protected within your agreements, have it spelled out, have a clear delineation so both parties know, certainly if you're dealing with another organization overseas, that you contain the rights to that, you hold them after the termination of any agreement, but do give some special thought to those in addition to the recorded issue that we discussed before.
And just kind of a postscript to what I said earlier, both for copyrights and trademarks, as Lindsay alluded to, your rights overseas, your ability to get preferential rights overseas, your ability to prevail in disputes overseas, oftentimes will be contingent on your U.S. registrations of both copyrights and trademarks. So in addition to the importance of, for instance, registering your trademarks overseas in foreign countries, you also want to make sure, of course, that your key trademarks are registered here with the U.S. Patent and Trademark Office. The same thing goes for your materials that are subject to copyright protection. Of course, you can own copyrights and have copyright protection and enforceable rights irrespective of registration with the U.S. Copyright Office, but registration enhances your rights and, very importantly, overseas enables you to enforce certain rights because those rights are subject to certain international conventions that many countries have signed. But if you don't have those copyrights registered with the U.S., then it's oftentimes difficult, if not impossible, to enforce those rights. And as Lindsay said, in your agreements, make sure that you're being very clear that, for instance, you're only licensing copyrights or trademarks for certain limited uses, that there are geographic and use-based and other limitations on the right to use as copyrights, trademarks, and other protected information. Things like donor lists or potential member lists are generally not subject to copyright protection because they're not creative and original enough, but they may well be trade secrets that are very much subject to protection. So use your contractual rights and obligations to be able to protect that information, put very strict limits on how the other parties can use that, prohibit them, of course, from going ahead and creating derivative works and then trying to register those with the bodies in those foreign countries that protect intellectual property. All those things are very, very important. We've unfortunately had to help too many U.S.-based nonprofits deal with these issues after the fact when they didn't do all those things, and it can become very, very difficult for you to enforce those rights in those situations.
And two more thoughts. Certainly your intellectual property lawyers here in the U.S. should be consulted, and they can guide you. I know our colleagues have affiliation around the globe that they work with on a regular basis so that you can ensure that the total package of your IP is protected. Whatever you're doing overseas isn't disrupted here, and vice versa in terms of coming up with a global strategy. That's an important issue to bear in mind. And then the second point is we mentioned a lot of things that are critical and should be in your agreements. Whenever you're dealing with persons from overseas and entities that are not as familiar with our system, you're going to get pushback because agreements that traditionally are entered into overseas tend to be much more condensed, brief perhaps, but it also leaves open the issue of interpretation. And although you may get pushback, if you find that you've got any authority in the negotiation, I would be certain to make positive that the provisions that you care about are in your agreement. It's not uncommon overseas to see a 2-page agreement, but if you've got something where it's a substantial business risk for you, you want to make sure that your important issues are addressed in writing so that should things fall apart, you've got a leg to stand on.
One of the areas where we've seen the greatest amount of problems and disputes has arisen in situations where you at least expect it. And oftentimes there's say we're dealing with trade and professional associations, and there's an affiliated kind of corresponding association or chapter type organization in a foreign country that's trying to do a lot of the same things as you are, and you want to kind of use them as to open a chapter of your organization in that country, and you enter into some sort of an affiliation agreement with them. At the beginning, everything seems really friendly and hunky-dory, and you're all on the same page, and you're all promoting the same mission. But the reality is, in their country at least, you may be viewed really as a competitor, or down the road you may be viewed as a competitor. And so you need to be very cognizant, thinking at the time that you enter into these agreements, certainly use written agreements like Lindsay said, but just keep in mind, assume that down the road this nice tight relationship is not going to be there, and that this organization may become a prime competitor of yours. So in terms of your trademarks, your copyrights, your valuable education materials, your conference materials, everything like that, that if you don't put proper protections on those, that entity overseas could turn around and start using those to put on the same types of programs and trade shows and conferences and publications in their country and effectively lock you out of that country or make it very difficult for you to operate. Keep those things in mind and kind of plan for that divorce at the time that you enter into the agreement.
Yeah, the other point is that oftentimes you don't see entities going overseas with their leading edge information or their leading edge products. So think about it. Do you have maybe an older generation or an older version that if you find that slips out, you're not as concerned as whatever you have, whatever your cutting edge. I certainly wouldn't lead with that.
And just one more thing to add there, we've also seen, and this is just something to bear in mind as another option, is where the U.S.-based nonprofit will consider creating a version, an international version, if you will, of their logo. So if they are going to enter into an affiliation with a similarly situated organization, maybe it's ABC International Chapter, and they'll register that, create the same protections, but then it's not as devastating, if you will, if there's a breach of the agreement and the logo is misused. Okay. All right, and so once again, we come back to the FCPA, and not to belabor this, but we do point this out as an important consideration in going overseas for several reasons. First of all, nonprofits are not exempt from FCPA investigations, which are implemented by the Department of Justice. Secondly, we've seen a great increase over the last 5 or 6 years in these investigations, and we've also seen trends where different industries are targeted. These may or may not be industries that your members are involved in, but in addition, we see just an overall renewed interest in due diligence and investigations regarding charitable donations. So then as a result, we once again go over it. So what are the provisions of the FCPA that are most important to all of you and your associations? There are 2 sets of provisions. There are the books and records provisions, which are applicable to publicly traded entities. So what we're going to focus on here are the anti-bribery provisions. And these provisions prohibit the paying of, offering, promising to pay, or authorizing to pay money or, quote, anything of value, which is an important phrase they snuck in there, with corrupt intent, directly or indirectly, to a, quote, foreign government official, which is a term that's defined quite broadly under the Act, or a political party official, for purposes of influencing an official act or decision, causing an official to fail to perform a lawful duty, or, and most importantly, obtaining or retaining business or securing an improper advantage. There are certain limited exceptions, but frankly, as the anti-corruption trend has become more globalized over the last few years, the FCPA for a long time was really the U.S. was the leader in this initiative. We now see a UK Bribery Act, for example, that's even more stringent. These limited exceptions and defenses have essentially been read out of the legislation. And so, as I said, nonprofits are not exempt. And so one of the first things that we see, and we often want to emphasize, is who is a foreign government official. This has been, as I said, interpreted quite broadly to include everyone from a ministerial customs official at the border to your more traditional understanding of who a foreign government official could be. Importantly, we've also seen foreign government officials as employees of government-owned institutions. For example, doctors in a state-owned hospital in China were interpreted as foreign government officials under the FCPA. And so when we look at trade associations, nonprofit associations, what kind of activities might be at-risk activities here? A 2008 investigation into a company called AG Medical Corporation, and albeit this is a corporation, comes to mind as a good example, though. And this was a situation where AGA was a device manufacturer of a medical device used for congenital heart defects. And in order to just garner interest in China, they distributed the device to various state-owned hospitals. And subsequently, their agent, InCountry, which we'll touch on in a moment, decided to offer basically incentives to those doctors to use the device and to distribute it in the hospitals. So in issuing a $2 million criminal penalty against AGA, the Department of Justice said that physicians employed by government-owned hospitals are foreign government officials. And this has become sort of a case that we look to ensure that the due diligence is done. Who are your agents, number one, and who are you dealing with? Could they be construed in that country as a government official? Which brings us to the next big point. In deciding how to go overseas and looking at your various options, oftentimes in dipping your toe in the water, you're going to be relying on representatives or agents in making your decisions and going out into the industry to see what kind of interest might be there. The actions of those agents and representatives, depending on what they are and what your relationship with them is, can result in liability to the U.S.-based nonprofit. And so going back to what kind of contract provisions should really be focused on in affiliating with another organization, we often want to recommend that there is an independent contractor relationship that's specified in the agreement. This offers sort of maybe a first layer of defense, but training anyone in your organization or your affiliated organization abroad on the implications of the FCPA, if it is a United Kingdom, if any organizations or the United Kingdom is otherwise involved, the UK Bribery Act is also important. And many nations, especially those that are members of the OECD, have national anti-corruption legislation as well, which also needs to be complied with. So these are all considerations, and we're happy to answer more detailed questions on them, but just really taking that first step to do due diligence on what are you donating, if it could be considered a donation, who are you donating it to, and what actions your agents might be taking on your behalf.
The anti-corruption spectrum has really changed over the last couple of years. As we mentioned before, the U.S. law has been around since '77, and the OECD kicked in several years back, requiring all 38 countries to be signatories. And as Carrie noted, the UK Bribery Act is the most recent, really, in a row of very significant efforts to curb global anti-corruption. From the U.S. perspective, what's been interesting is that you effectively see law developed by settlement. And people will scratch their head and say, well, this is a very significant area. You know, how come folks aren't challenging it more frequently? And what you find is that, number one, the penalties have increased so significantly that it's not uncommon to see $100 million penalties assessed. So with those figures, you think, wow, you would hope that someone would step to the fore and, you know, really put it to the DOJ and see, you know, whether or not they have a decent case. But the teeth that are behind these huge penalties is that if entities are indicted or found to have violated these provisions, oftentimes they'll lose their ability to contract with the government. And so recognizing that, they say, you know what, we don't want to challenge that, we would rather settle. So you see these significant settlements, not only in the U.S., but now more and more cross-border settlements, where you see the Siemens case, for example, the U.S. and Germany cooperated. You see that much more frequently. The other point is that historically the FCPA had been targeted at entities. And so the trend of late has been to effectively go after individuals. And many of you may have read in the paper about the Gabon's sting, which recently, I think as of yesterday, the cases were dismissed as the latest update. But that was really where you saw if an individual was going to be going to jail, they were going to stand up and challenge it. So you've seen increased enforcement because of these significant penalties that effectively get assessed and then, if you will, feed the machine with all of this money coming back in, more enforcement, more cases, more enforcers, etc. So it becomes a cycle. We have seen where there has been greater challenge to some of these interpretations. Another case, one of our colleagues worked successfully with the Lindsay Manufacturing to a successful result there, again challenging some of these definitional issues as to who is a foreign governmental official, and some of the others where you're slicing between the lines. The other important note is that we were sort of slow to progress to this, and people didn't want to go in and challenge. There is a procedure where you can go in. It's called the opinion procedure review. You can go into the government and say, here are my set of facts, and you tell me whether or not there's going to be action from it. There was an opinion release that was from July 2010 involving a U.S.-based nonprofit microfinance institution that had set up in Asia a wholly owned subsidiary that wanted to get some guidance in terms of potential grantees. And so they explained that we're going to go through this round of effectively 3 phases of due diligence. First, publicly available information. Then the next phase, we're going to probe into some of the documents and records and get more concrete information. And then as potentials fell away, saying, well, this one isn't satisfactory because of this reason, or this one still wears a governmental hat, they narrowed down to one potential and had interviews. And what they found was, even though it was a former government official on the board of directors of this entity, they realized that it's in an unrelated area. And they were able to work up some conditions, effectively rules of the road, that should that entity agree with and follow, that they wouldn't, essentially be a no action from DOJ. And so they looked, for example, at staggering payment of grant funds rather than a big chunk of payment up front. Ongoing monitoring and auditing, that's always a critical component to having the parties with whom you're dealing sign a certification that they agree, they understand that you're subject to, and they agree that they will not violate. And then having the ability to go in and actually monitor and audit them. They also required some earmarked funds only to go for capacity building. So they said, yes, okay, the funds can be out there, but we're going to limit the use. We're going to make sure that we've got some controls on this. And then a prohibition on compensating any of the board members, because although one was a former government official and one was even a current, they did not receive compensation in the normal course, and so it was important for that to follow through as well. And then, in addition, they wanted to have some anti-corruption compliance procedures kick in. So you see this more and more. You don't, however, see a lot of folks going in with the early review request. And I think, frankly, people just want to fly low under the radar, because once you've gone in formally, you may get your no action letter, but heaven forbid you cross your toe over any of these provisions that are required. They certainly have the shorthand of who you are and what you're intending to do overseas. So each year you really only see a couple of review procedures even requested. But that is an option for folks. Yeah, question?
Lived in a dozen European countries. There's a difference between high and low trust society.
Mm-hmm.
In the United States and Europe, the low trust society, everything is written down. That's how we got read. Higher trust society is all social.
Right.
And that social also involves sometimes exchange of gifts, meals, all sorts of non-expensive things. Just part of the social building. Anything of value, that what is interpreted as that illegal?
Yeah. So the question was discussion in the context of high-risk and low-risk countries, where the U.S. being a society where we like everything in writing, and it's not effectively by handshake. So the question was, oftentimes it's just practice to give gifts, be it whatever value, small value, and that's the norm. So the definition of anything of value, does that mean that these would be prohibited? Here you have to take a step back and say, okay, let's think about what would rise to the level of potential prosecution. Obviously, there's some judgment there in terms of bringing a case, bringing the formality of a case. If it's something with your association's logo on it, I'm sure you're fine. However, if it goes, it's a sliding scale. If it goes beyond, if it's a dinner, okay, fine. If it becomes a lavish dinner for the targeted person, their family, is it a business trip where they're coming to see your operations? That's probably fine. If it's a business trip coming to see your operations with a side trip to Vegas and a golf junket, I would think not. So again, you've got to give some thought in terms of what you're providing. The phrase is anything of value. So the intent was not to have it limited to pure monetary, currency gifts, but to extend to things in kind. It's also important to think about, who you're dealing with. You can't do indirectly what you can't do directly here. And so the government will look and see, and certainly the cases and settlements that are out there will examine, Are you giving the gift to the spouse of the person that you're targeting? Are you giving, are you providing employment for a nephew that may not be qualified for that particular job or responsibility? So it's a whole host of factors that go in. At the end of the day, you have to stop and think, would this particular action rise to the level of something that the Department of Justice would pursue? On the other hand, small payments, which are authorized in the books under the grease payments or facilitation payments in the U.S. are not permitted in any other country. And what we've also seen is that you can say, well, it's just $20 to basically have my permit reviewed at the top of the pile instead of the bottom of the pile. Okay, maybe one time, but if in the normal course you need 100 permits a month, it certainly adds up. So, again, you've got to kind of slice and dice and look at the full context of the issues.
And I would add another example of the anything of value, and this goes to doing due diligence on any donations that you might be making. There was a case where a particular U.S.-based entity contributed a pretty sizable amount of money to the favorite charity of a government official in Germany. And that was investigated because they felt, the Department of Justice felt that by doing so, that U.S. government, or that U.S. corporation had obtained or retained the business of the German government. A grant for a contract was at stake. And so really, what is the ultimate goal of whatever, dinner should also be considered. And so, yeah, I think that's all. Moving on.
So our last topic is one that you may scratch your head a little bit and go, U.S. export controls, do these folks think we're a large defense contractor? How does this apply to us? But the reality is that the U.S. export controls are varied. They're really two-pronged. On the one hand, they do control the laws and regulations control the export of things, to include software and technology that are important and sensitive to the government. There are two agencies, State Department and Commerce Department. State Department governs the defense articles, so for the most part, those would not be involved here. But the Commerce Department governs what are called dual use, so they can be used equally in a defense setting as well as commercially, but they haven't been specially designed for a military or defense purpose. Okay, well, what all does that mean? There are items that, for example, laptops, which have encryption, software and technology that has encryption, it's controlled at certain levels. And the U.S. government monitors and puts these restrictions in place for U.S. origin things, as well as anything in the U.S. leaving the U.S. So you can have some piece of medical equipment, perhaps, that your industry constituents use, that they would like to export for use in a trade show, in a demo overseas. It may be controlled, and it may require a license to leave the U.S. Even if it were, let's say it was made in Germany and brought in here, but then you're going to package it up for your trade show and send it overseas, there may be a license requirement for that. So that's the one hand where the controls govern both the things, the widgets, if you will, as well as the software and technology that are associated with that. And those controls it's a patchwork. It's a who, what, when, where. Where is it going? Who is going to be the recipient? Whether or not you need a license. It's not a simple system, and in fact, the government currently is reviewing everything to try and simplify it down to a single licensing agency. I'm not going to hold my breath on that because it does require legislation to make that happen, and we're in the midst of seeing actually the analysis of what should be on this list. So taking that in mind, the other half is consideration of transactional restrictions. And you just have to open the paper to see certain countries where there's countrywide embargoes. Cuba, Iran, North Korea, Syria. These are all based on trade policy, so it ebbs and flows with the timing of who's our friend and who's our foe at any given point. But those are very important to bear in mind, because it's not simply I can't send my notebook to Iran. It's I can't do business with Iran, and I can't do it either directly or indirectly. And you can't rely on certain service providers that are tied to these governments, as well as certain other listed entities that are restricted. So when you're undertaking your transaction overseas, you say, okay, I know I can't do business in these countries, but perhaps you're putting on a forum in a third country, and a participant wants to come from Iran to your trade association meeting, and they're going to send their funds through a particular bank that might be on a list. So you've got to give some consideration. It's not as clean as simply sending something to a particular country that's restricted. And in fact, over the years, there's been some guidance. There was guidance that was put out in 2003 that for Iran, it was dealing with Iran, for example, that said the formation in Iran of a nonprofit's chapters, special interest group, or the like would constitute provision of services to Iran that's prohibited. So you certainly can't form an entity over there. Okay, we get that. But then within the guidance, there are certain exemptions. You think, okay, well, maybe there's some room to maneuver. There's a general exemption for some informational materials. So if you have something that's already packaged up, perhaps you could forward the informational materials to them. But if you were to say, well, you know what, this package of info really doesn't suit their need, let's rearrange it and target it more for who we think that audience is. You would not be permitted to do that. So it's a gray zone, frankly, whenever you're dealing with these, the five bad countries, if you will, where the more strict embargoes are, as well as working through your agents and your other parties. Are they on any of these various lists? Are you restricted from financial transactions because of banks that are affiliated with these various countries? So collecting membership fees, maybe that's okay, but not if you're going to, send it through a restricted bank or other fund. These change daily. We see, about every other week, there's a new executive order coming out that's either identifying further entities to add to these lists or making tighter restrictions on just the transactions themselves. So while export controls isn't in the normal course rise high to your list of things to think about, certainly from a global perspective, you should bear it in mind.
And before we move on, we have a question from one of our online participants that's directly on point. And he's asking if you've encountered a similar situation or have any advice or guidance. An association publishes a technical journal. A professor from Iran sought to be on the peer review committee. Another committee member who was a professor at a U.S. institution said he would not participate if the Iranian was on the committee because the Iranian's participation would violate export control laws.
This sounds like a law school exam.
And it is coming from a lawyer.
Identify the issues.
To which we would say it depends. Yeah. I mean, you really would have to further define the facts because they're so fact-specific. Who's the entity? Is that professor affiliated? Most educational institutions overseas have state ties. So my instinct would tell me you would certainly need to get all of the details and facts before progressing.
Additionally, whether there was any payment to be made for the services, all of those factors would be considered in that question. And I would also add to what Lindsay was saying on the economic sanctions. We included an acronym in our slide, but unfortunately, I'm sorry, we didn't define it. It's the OFAC, and that is the department within Treasury that is the Office of Foreign Assets Control. The OFAC is the entity that basically administers and implements these economic sanctions. What's helpful, we often see in situations like the hypothetical that was brought up, or where you might get, as Lindsay used as an example, a potential attendee at an event that might, for example, is coming from Iran or Cuba. There is the OFAC issues what's called the Specially Designated Nationals List. This is updated daily, I think, on their website. It's easily found via Google, and we can send out information summarizing some of these points as well. But checking those or screening those potential attendees, for example, or speakers is a good step, due diligence step, in preparing for overseas events.
And I guess the last point that I would make, certainly for U.S. export controls and for the economic sanctions, is they are fact-specific. Oftentimes, we'll dialogue with a particular client to give our advice in terms of what proactive steps that you can undertake. We also often call the various organizations, the agencies, on a no-names basis and try and lay out, what the proposal is. Now, the government is always quick to say, well, any advice provided orally, you can't really take it to the bank. But it gives you a sense of whether or not you're suddenly wading into more treacherous territory or not. The OFAC regs, as we refer to, are very complicated and fast changing. So it is one to think about as you're pursuing international operations. I think with that, we've covered the topics and are close on time.
We are very close on time. We have about 5 minutes left for questions from here in the room or those of you online. Anyone have any questions for Lindsay or Carrie or myself? Yeah, Greta?
Well, it's a very practical question. To do a few small workshops in Brussels, what are the registration requirements and how onerous are they?
Well,
You want to repeat the question?
Yes. So the question was to do a few short workshops in Brussels. What are the registration requirements and how onerous? You need to give some thought in terms of if it's a one-time in deal. Generally, and this is again, there's a footnote caveat. Generally, nonprofits are permitted to do so. We did talk about the Singapore example before, where you needed to go in and register. If you start with a progressive amount of activity, you really need to think about registering. I would suggest we could certainly tap in with our colleagues over in Brussels on that. Most often if it's a one-time, we're going to give it one shot. We're not going to have a formal operation there. We're going to do everything from overseas. You're on a safer ground than once you start doing more and more. The folks say, I think we've seen this group before, and weren't they in last month, and they're coming again in 2 months? I would seriously consider then the registration side. Europe generally is pretty efficient in terms of getting registered. It's some of the other, it's usually Asia, Southeast Asia, that can be more cumbersome. Sure.
Other questions? Yeah, right here.
On one of those bullets on the earlier slides, you talked about or mentioned the current red flag countries. Would you care to kind of list maybe the top 5 that you ought to be aware of, outside of the OFAC?
If you're in Denmark, you're probably okay.
Yeah, but how about China?
China's pretty high up on the list. China, Nigeria. What's interesting about China is that it's high on the list, and I don't know if we have we can forward that or make that available, the Transparency International listing. The U.S. is not, I think U.S. is 17 or something, so, just bear that in mind in terms of context. But China tends to be high on the list. What's ironic, though, is they've got pretty significant anti-corruption laws in China as well. Now, the question is the law can be on the books, but how is it enforced? And it tends to be enforced more for non-domestic entities in China, which you often see. Asia can be pretty high.
How about the Middle East and Latin America?
Yes and yes.
He was asking about Middle East and Latin America.
Yes, Middle East and Latin America. Countries like Brazil, where it's complicated. The Middle East can be tricky as well. Again, it depends on which country you're talking about. But we can make the list available.
Great. Thank you.
You're welcome.
Oh, yeah, right here, Ona.
Really more of a comment than a question, but as you were sort of going through the anti-bribery, FCPA, UK Anti-Bribery Act discussion, I was actually looking at our policy and sort of doing a crosswalk, and it seems to me that organizations would be well advised to make sure that there is a close crosswalk between their conflict of interest policy and their code of ethics. I mean, those two things should line up.
Yeah, that's an excellent point. So during the discussion about the anti-corruption, one of our attendees was examining her entity's policy and made the point that it's important to consider your code of ethics policy and your and your conflict of interest provisions as well. What we see is that because of all of the focus and review on anti-corruption, some of the others may not have been updated as recently, but you certainly want to make sure that they're both consistent, because having them inconsistent would be a problem. That's a good point. Thank you.
All right, time for 2 more questions.
Thank you. Are there any benefits for associations that use trade agreements with South Korea?
That's a good question.
Repeat that.
Yes, sorry, repeat the question. Are there any benefits for the trade association with the new free trade agreement with South Korea? I haven't focused on that from a perspective of a nonprofit, but I would certainly think that it provides the context of open dialogue and engagement. I mean, generally what you see with free trade agreements is the opportunity to import and export freely between the entities, either at free or a reduced rate, but you also see some benefits in terms of registration and forming an entity in that jurisdiction. So I've not specifically examined that, but I would think that they would be more favorable now.
Okay, one more question over here.
We have a large percentage of our corporate members that are based in Dubai, and so our board wanted us to start a Middle East chapter, loosely based out of Dubai, but with no presence there. We're handling everything from our end. Volunteers from our corporate members over there are volunteering in-kind donations of space and food and things like that to hold small networking sessions and things like this. And we're not sure what our exposure is because it doesn't quite fall into any of the 5 sort of risk categories that we went through before because we have no presence there. But we are using sort of an ISOA Middle East chapter logo. And so there's some things that should we register, should we not? There's some gray areas there.
So the question was, one of the entities has involvement in Dubai to work with volunteers of your organization who are there providing in-kind space and donations of time and effort. They are using the logo, as I understand, and are having some activities on a regular or irregular basis.
Yeah, not too often.
Not too often. Okay, quarterly. You'd have to take a step back and say, what would the local government perceive? They're seeing more regular than irregular activity if it's quarterly. They're seeing the use of a logo. So as far as they would perceive, you've got certain levels of activity. Now, putting on my defense hat, I would say that you certainly haven't formalized anything there, but you're in the gray zone, and I would suggest giving consideration to getting advice from a local perspective on that, because the rules can be very different. And even though you haven't formalized your organization there, just the repetitive nature of a presence could be interpreted as doing business there.
Yeah, it certainly has a lot of the hallmarks to me of a classic agency relationship, where even though your association isn't actually having an office there or employees there or hiring a management company, you're utilizing your corporate members who are based there as a proxy to carry out activities in your behalf, and that's certainly how the Dubai government may view it. Unfortunately, we're out of time. Our speakers will stick around afterward. For those of you in the room who have additional questions, always feel free to email me if you have questions. For those of you on the line, if we didn't get time to get to you, thank you very much to Lindsay and Carrie for a terrific job, and thank you all for coming. We hope to see you next month. Thank you.
Thank you.
Thank you. Please stand by.